Well, good evening, everyone. We are just filing in here today on this beautiful Wednesday evening. Good as always to have you all with us today. Hello and welcome to the latest forum in our Issues That Matter series. Tonight's topic is readers' rights, excuse me. I'm getting my forums confused. Readers' rights, a First Amendment discussion on book bans. This series is presented by the Central Arkansas Library System, the League of Women Voters of Pulaski County, and Little Rock Public Radio, KUAR 89.1. I'm Daniel Breen. I am the news director of Little Rock Public Radio, and I'll be guiding our discussion this evening. This Zoom forum is being recorded for a later broadcast on KUAR with air dates to be announced. Well, before I introduce our panelists for this evening, I want to thank both the Central Arkansas Library System and the League of Women Voters of Pulaski County for partnering up with us for this event. I'd also like to give a brief explanation over the format for this online forum. We'll be asking our panelists a variety of questions, but we also want to hear from our viewers. If you have a question, please use the chat function here on Zoom to ask it. We are also monitoring our Facebook and YouTube streams, so if you are watching through Facebook and leave a question there, we should be able to see those as well. Well, all of our panelists tonight received our topics and questions ahead of time so they could prepare, come with ideas, statistics, whatever they would like to bring to the table. For each question asked, participants are free to answer questions and comment on each other's input. We'll then move on to the next question. And at the end of our conversation, we will have some time to answer those questions again from our viewers. And I just want to have one more note before we begin tonight. We will be talking about book bans and new legislation relating to libraries here in Arkansas. Just a note of full disclosure, the Central Arkansas Library System is a partner with us in this event. However, here at Little Rock Public Radio, we maintain editorial independence. The content of our discussion tonight is in no way influenced by or censored by any outside entity whatsoever. Well, without further ado, please help me welcome our participants to the forum. We have Adam Webb. He is the director of the Garland County Library. We have John DiPippa. He is Dean Emeritus of the UA Little Rock William H. Bowen School of Law. And last but certainly not least, we have Josie Lenora. She is our steadfast politics and government reporter at Little Rock Public Radio. I want to thank you all for joining us tonight. I'm going to start in not quite the order that I introduced you. I'm going to start with Adam first, then go to Josie, then go to Dean DiPippa, and then I'm going to switch it up every time. So I'm going to go in that order first, then Josie, you will start the next question, et cetera, et cetera. We'll figure it out. Well, without further ado, I want to start with our first question of the evening. And again, it goes to you, Adam Webb. How has the book banning movement evolved over the years in what you've seen?
You know, I've been in libraries for about 17 years now, and in all of my working experience and in my education as a library director, book banning is always the same. It always comes from a morality perspective. Whether that is, the caliph that burned down the Library of Alexandria in 600 AD because he didn't believe in what they had in that library because of moral grounds up till today, it's always the same. In our country in particular, our history of book banning anyway has been very much rooted in puritanical sentimentality. But the thing that is different this day and age, as opposed to previous book banning eras, is social media. By and large, you're seeing this almost as a function of meme culture, rather than some sort of organic outcropping of people who all are finding the same problem. I mentioned to someone earlier today, if you've watched one city council meeting or a quorum court meeting about book banning and listened to the passages that are read out loud, you've seen them all. It's always the same books. It's the same content. It's the same list of books that's shared through social media. And so this isn't like early in my days as a librarian when, once a year you would get a reconsideration of materials form because someone organically came across a book that they found offensive. Instead, you're having people come in with Excel spreadsheets and lists, and oftentimes they don't have kids who use your library. They're coming in to register for a library card on the same day that they're filing objections about books that are in the library. So outside of that, I think that's the really big difference in today's book banning culture or censorship culture, whatever you want to call it. It's not just books that are being challenged, but certainly as a catch-all phrase, I think that works for what we're talking about.
All right. Thank you very much, Mr. Webb. Yes, please go ahead.
Adam, if I can add on to that, you're absolutely right. If you've sort of been through one book ban, you've been through them all. But what's interesting about this is people shouldn't think that this just arises sort of organically when somebody decides, oh my gosh, I'm going to do something about books, and they find a list. This is part of a long-standing political movement on the right that goes back at least 50 years. And in the 70s, you would go to a convention and they'd hand you a list of books. And then you'd show up at your library and say, ban these books. Social media takes the place of the convention and the paper list. But the themes are almost exactly the same. I'm going to talk about a 1982 Supreme Court case that essentially could be happening today, because the books on the list and the themes that people want banned are almost identical to what you're hearing today.
Thank you very much, Mr. DiPippa. Josie, again, the question, how has the book banning movement evolved over the years?
Well, I'm young, I'm 26, but one thing I've noticed in talking to other people, one of the people I talked to was Brian Neters, and he's an attorney who was involved in the Cedarville case. There was a court case to ban Harry Potter books. And one thing he said to me is, he's currently involved in the Crawford County lawsuit where they're relocating books in the library. And he said there's been a change in the culture. It's hard to imagine 10 years ago, people putting billboards on the side of the highway calling for the termination of a library director, or people calling librarians pedophiles and groomers. I saw one public opinion commenter who said that librarians were metaphorically eating babies. And it's kind of hard to imagine that kind of culture existed even just 20 years ago when the book bannings of Harry Potter happened. That was in about 2002. But again, I'm also very young, so it could be different. But everyone I've talked to said that the culture is a little bit meaner when it comes to book banning than there has been in the past.
All right. Thank you very much, Josie. Next question tonight, going to you, going to you again, Josie. What content are we seeing right now that is raising the most objections from parents?
There's a couple different categories. So what I've been noticing is it's a lot of books with LGBTQ characters. One book that is a huge cause celeb for people who want to ban and relocate books is a queer memoir by George M. Johnson. It's called All Boys Aren't Blue. It actually won an award here in Arkansas. It won the Charlie Mae Simon Award. Quorum Court leader Matt Brumley, who was led the charge or was involved in firing the library director in Saline County, Patty Hector. That was a book that he brought up a lot. And it's a book you hear read from a lot. It does describe LGBTQ sex scenes. And that's something that makes people really uncomfortable. A second bucket I've noticed is just sex ed books like Sex is a Funny Word, It's Perfectly Normal, Sex, a Book for Teens. We saw Representative Stephen Meeks, a Republican here in Arkansas, was really upset about one of those books in his library, and he tried to get it challenged and was unsuccessful. And then there's this other category of books which aren't even remotely pornographic. And those are books like Llama Glamorama is a book in Crawford County that they tried to relocate. And we talked about it a lot in the office. It's literally a book about a dancing llama. And Amanda Stevens, one of the board members on the library board, she didn't like it because she said it was pushing a social issue. They, in Crawford County, relocated a whole bunch of books. There was one about a kid being in a wheelchair that they relocated. They relocated books about world religions. They relocated a book called My Family, Your Family, which is literally just a children's book that shows different pictures of different families. And there are a couple pictures of a kid standing next to two same-sex people. So it's like implied that they're the parents. One called Uncle Bobby's Wedding, about a girl going to a gay wedding. So it's like children's picture books about gay parents, these kind of YA novel, like All Boys Aren't Blue. And then there's the sex ed books. So the kind of the categories that I've been noticing.
All right. Thank you, Josie. John DiPippa, you're up next.
It's probably true. I think it is true that LGBTQ issues have risen in prominence in sort of current debates, but I think there's also a category of race-related books that make people uncomfortable that you see being objected to in other places. And that's been a consistent theme throughout. And it might be that books that make people feel uncomfortable about the status quo and about their place in it are subject to these objections.
All right. And Adam Webb, interested in your perspective as a library director, again, the question, what content are we seeing right now that's raising the most objections?
I think Josie and John both hit the nail on the head. It's books dealing with LGBTQ issues, books that deal with sexual identity or gender orientation, and books on race. That is, I mean, if you wanted to put those all into one bucket, that's going to be 95% of book challenges. To Josie's point, those books are not designed to titillate. If you look at a book like All Boys Aren't Blue, the writer is talking about experiences that happened to him. It's an autobiography, and they're not designed to titillate. These stories are not meant to be sexually exciting or pornographic. They are cautionary tales. He's talking about abuse that happened to him in his life. And when you look at Arkansas statistics in regards to child sexual abuse and teen pregnancy and things like that, it's really hard as a librarian to say, I shouldn't have material that deals with these issues, because in a county like Garland County, we've got 100,000 people. I could bet dollars to donuts. I know Hot Springs is the gambling town, but I'd wager good money that a lot of my library patrons have dealt with child sexual abuse. And when you hear stories about a book like It's Perfectly Normal having been used as evidence in a child sexual abuse case where a child read that book and told their mom, like, this is happening to me. What's in this book is happening to me. And it actually stopped abuse in the home. I have a really hard time reconciling that sort of evidence when in the contrary is someone's discomfort. And Josie had mentioned grooming earlier, which is a word that really gets my blood boiling. As a librarian, I'm not requiring anybody to read anything when they come into the library. When you come in, you're coming in with intent to educate yourself and to read information that you think is appropriate for you. And this is kind of dancing around the question that you're asking about content and what we're seeing raising objections. Libraries have always had content that people will find objectionable because we're tasked with providing information for an entire community. And that includes people who you disagree with, whether it's ideologically, religiously, whatever your flavors are. The library is going to have something that's going to offend you, and any good library is going to be run that way. And so they're both right. The content that most people are objecting to these days are books on LGBTQ issues. They're books dealing with race. That doesn't mean that those issues don't exist in your community, and there certainly doesn't mean that the library should shy away from having books that deal with those issues.
Well, we appreciate your insight, Mr. Webb. If you are just tuning in, you are watching Issues That Matter, Readers' Rights, a First Amendment discussion on book bans. This series is presented by the Central Arkansas Library System, the League of Women Voters of Pulaski County, and Little Rock Public Radio. This virtual forum is being recorded for broadcast and will air at a later date on KYR FM 89.1. Our guests this evening are Adam Webb, who you just heard from. He is the director of the Garland County Library. We also have John DiPippa with us. He's the Dean Emeritus of UA Little Rock's Bowen School of Law. And we have Josie Lenora, politics and government reporter at Little Rock Public Radio. Moving on to our next question, and I want to start with you, Dean DiPippa. I think you know a little something or other about this. What does the First Amendment of the U.S. Constitution say about library content?
Okay, thank you. This is probably a good time for me to mention that even though I have a Bowen School of Law background behind me, and I'm Dean Emeritus, nothing I say is the position of the school or UALR, or I should be associated with that. However, in my background, I am associated with that bike, and so I'll take credit for that. Well, Here's the thing about the First Amendment. It doesn't say very much about anything. The text of the First Amendment says that the government shall not prohibit the freedom of speech. That's all it says about speech. And so whatever the First Amendment's meaning is developed in court cases. And you would think that there might be a lot of court cases dealing with libraries. There aren't. There are 3 Supreme Court cases that deal either directly or indirectly with libraries. And they really don't give much guidance. Now, you can sort of pick some pieces out, and I'll try to pick them out because it's a pretty sprawling topic and make it as straightforward as I can. But it starts in 1982, where a group of parents went to the library board or the county board and asked to have 11 books banned from the library. And they were on themes that we've talked about today, sexual matters, race, etc. And as the case went through the courts, it got up to the Supreme Court, and the Supreme Court said that the county board could not ban those books. The problem is you didn't have 5 justices, a majority, agree on the reason for that. And the reason really matters. So 4 justices said, you know, you can't ban books just because you don't like the content or the viewpoint. Except in a school, you might have a little more leeway. And so the law distinguishes between elementary and secondary school libraries, where school officials might have a little more control over books, and public libraries, which would be in a higher, more protected category. And even within that category, you have to ask, well, what about older kids? Isn't there a difference between grade school kids and young kids? And so you might actually see 3 different rules of law, depending on the kind of library you're talking about. The court then discussed another case involving removing books, or at least something like the statute we have here, which prevented booksellers, libraries from giving material harmful to minors. And then they modeled that on the official obscenity definition for adults in the Supreme Court. Arkansas law copied that. So that's part of this current issue. But the court asked the Virginia Supreme Court to say, well, what does this mean? And the Virginia Supreme Court said, harmful to minors has to be variable. That is, something that's harmful to a 6-year-old, the material, might not be harmful to a 17-year-old. And if the statute is understood to mean any material harmful to any minors, then it's going to be unconstitutional. The Arkansas Supreme Court doesn't follow that viewpoint. The Arkansas Supreme Court says any material harmful to minors means harmful to any minors. That's their official opinion. And then finally, the Supreme Court in 2003 decided a case involving library filters, where the United States Congress gave money to libraries, public libraries and school libraries, on the condition that they would impose filters and filter out objectionable content. And the court said, well, that's not a problem. If the government gives you money, they can attach reasonable conditions to it. And this condition is reasonable because adults who might use the internet can turn the filter off or get the library to turn it off. And so you bring that forward to currently, and if you ask me what does the Supreme Court say, I think the Supreme Court says public libraries probably can't remove books just because they don't like the viewpoint. Elementary school libraries probably have lots of leeway to include books or not. And secondary school libraries are going to be in the middle, depending on the nature of the content and the age of the student. So that's as quick and dirty as I can get about library law.
Well, we certainly appreciate your expertise on this, Dean DiPippa. Going next to you, Adam Webb, again, the question, just in your experience as a library director, what has been your understanding about the First Amendment, or really just the law writ large, says about the content in your library?
So I'll expand a bit on what John said. I've been talking about censorship in libraries, it seems, constantly for the last couple of years. So I'm almost like a parrot that lives in a law office. Like I've heard enough terms that I can repeat them, but I don't really know if I have the, the actual legal wherewithal to understand exactly what they mean. For librarians, whenever we are looking at material and whether it is covered under the First Amendment, whether it's protections or not, there's some really interesting kind of background to that as far as this right to receive information, which is kind of the flip side of the coin to the right of free speech. Like you got the right to say what you want, you got the right to think what you want, you also have the right to listen to other people or read what other people have to say. Interestingly, a lot of those rights came from Supreme Court cases that came from religious organizations, the very same folks who might object to books in the library. Jehovah's Witnesses in particular have a lot of Supreme Court cases and precedent that actually help libraries with this concept of the right to receive information. So once we've ordered a book for our library and it's on the shelves, we have to take a lot of consideration if someone objects to it. And the biggest one that you see a lot of people talking about is obscenity. And there's this disconnect between what is legally obscene and what an individual might use anecdotally as the word saying, I think this is obscene. But libraries really have to look at material under this legal concept of obscenity, which is really a judicial concept. If someone challenges a book on charges of obscenity, it's not really for me to determine whether it's obscene or not. Under Arkansas law, it's a judge. A judge actually can adjudicate whether a book is obscene or not using what's called the Miller test. And the prongs of the Miller test, there's three of them. Whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. So you have to take the material as a whole and say, okay, this whole thing appeals to the prurient interest, which is like an unhealthy, degrading sexual obsession. Whether the work depicts in a patently offensive way sexual conduct, and it's not an and or, it's you got to fail all three prongs of the Miller test for something to be declared obscene, as far as I understand it. And John can, okay, John's nodding, so I haven't spoken wrongly yet. Whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. And when you have people come to your quorum court meetings or your library board meetings, they're reading passages out of context. Yeah, some of those sound really shocking, but they're meant to shock. Like it's for effect. And if I were to say to someone who wanted to challenge a book, instead of just reading these passages out of the book, if you would start from chapter 1, page 1, and read that entire book in this meeting, and then we'll determine whether or not it needs to be in the library. I think we would probably have a much different outcome on a lot of these books that are being vilified. So as far as those First Amendment protections go, there are some constitutional guardrails that libraries have to stay in. For me anyway, in Garland County, our personnel handbook says very explicitly, if I do things that I know are unconstitutional or that infringe on a person's constitutional rights, that I'll lose my job. So a lot of this is self-preservation for me. I want to keep being the library director. This is a job that I really wanted, and I'm not going to jeopardize it by infringing someone's constitutional rights, as far as I understand them.
And Adam, what you said was perfect. Let me just add on to it. The Arkansas law we're talking about makes it a crime to furnish, etc., information that's harmful to minors. Harmful to minors is defined exactly the way Adam described obscenity, only the words to minors are added at the end of every one of those prongs. So it's appeal to the prurient interest of minors. Depict patently offensive sexual conduct that violates community standards to minors. So all of that is sort of scaled back toward a focus on kids. Otherwise, it's identical to the Miller test.
And thank you both. And we will be delving a little bit deeper into the Arkansas library law here in just a minute, but I want to go to you, Josie Lenora. Again, the question, what does the First Amendment of the U.S. Constitution say about library content?
I'm kind of seeing this argument right now from a lot of the people that support book bannings and relocations, which is that they're not banning the books, they're just putting them in a restricted section, or they're not banning the books, they're just putting them up on high shelves. So to go back to the example in Crawford County, where they took a bunch of children's books and LGBTQ books and put them up on high shelves. I have talked to people who live in Crawford County who say it's embarrassing and humiliating to have to go to that section. But the idea was they put it up on high shelves so children couldn't reach it. And there are these completely fascinating library board debates where you have townspeople arguing about where do we put the John Oliver Bunny book? We put it back in the children's section or we put it in this restricted section. They're getting sued right now. I know that in Saline County, Patty Hector was fired for not doing that. So there's this interesting kind of parallel there. It's hard to get people who support book bannings and book relocations to talk to you on the record. One guy I talked to, he told me that he felt that putting the John Oliver Gay Bunny book in a restricted section for everyone under 18 was sort of like a safety measure, even if, it's better safe than sorry. And I pointed out to him, I was like, are you uncomfortable with a 17-year-old reading that book? And he said he thought it was just like a good precaution. It was a good precaution to put that in a restricted section. And so you hear that a lot. It's like we're protecting the kids. The lawyer who is supportive of relocating books in Crawford County, he called the First Amendment a balancing test. And so you're seeing this kind of idea that like, well, as long as we're protecting the children, the relocations, they don't actually constitute banning. So that's kind of the argument that the people who support it are making.
All right, well, thank you very much, Josie. Moving on to our next question this evening, about at the halfway point of our conversation tonight. What is the status of the law passed by the legislature here in Arkansas earlier this year, which opens up librarians to criminal penalties for providing quote unquote harmful content to minors? What content does that include? And I will start with you, Adam Webb.
Yeah, so 2 sections of that law are currently enjoined. There was a lawsuit, or is a lawsuit, that's challenging Act 372. I'm one of the plaintiffs. There are, I can't remember how many, 16 or 17 plaintiffs, something along those lines. It's a significant list. And it's currently been enjoined, a preliminary injunction out of Western District Court, Judge Brooks's court up in Fayetteville. He enjoined sections 1 and section 5. Please correct me if I'm wrong, if anybody. Yeah, 1 and 5. And those were the 2 that were the most odorous of the law. Sections 2 and 3 both just kind of reiterated, well, at least section 3 just reiterated what the law was, that if something has been legally declared obscene, that a library can't loan that material. Nobody had a problem with that section of the law. Section 2, as far as I understood it, was more of a protection, saying you couldn't go into a library and arrest the library director for claims of obscenity, that there actually had to be a declaration that something was obscene before you could go and arrest a librarian. That's been removed. That's more of a saber rattling issue than anything. But sections 1 and 5 dealt with furnishing harmful items to minors, and then the reconsideration process in public libraries. The issues in both of those were reviewed very eloquently, I thought, by Judge Brooks, who enjoined both of those sections of the law and said that they're not enforceable right now in a preliminary injunction. So they never actually went into effect. Section 4, which deals with school libraries, really just codified what a lot of school libraries already had in place, and they already had to have in place by Arkansas code, which was a reconsideration process for parents or guardians of students in the school district. The issue, or at least one of the bigger issues with section 5, was it just said a person affected can challenge library materials. It didn't have to be somebody who actually uses your library. It didn't have to be somebody who lives in the state of Arkansas, just a person affected, and it didn't really define that. And then section 6 is about being able to disclose what's in or what a child has checked out on their library account. And it says that a library can. It doesn't say that they have to, but it says that they can, which, as a librarian, solves some logistical issues when a parent has misplaced some of the books that their kid has checked out. Before Act 372, you couldn't tell a parent what was on their 4-year-old's library card, even if the parent was the one who checked them out. And so it just kind of made this kind of awkward two-step. So for me, it's really kind of actually helped out in a couple of scenarios, but I can't say anything nice about the rest of the bill.
Well, thank you very much, Mr. Webb. Josie Lenora, you're up next.
I talked to Senator Dan Sullivan, who authored the bill, in his office about it. He couldn't name a book that bothered him, but his ideology behind it was that he just wanted to create a law so that courts could decide whether or not a book should be banned or not. The problem is then now you have a situation where you could hypothetically clog up the court system for years with First Amendment lawsuits and violations. And the point that Adam Webb made just a couple seconds ago, which is it doesn't even actually have to be people who even use that library. I talked to Nate Coulter, the head of the CALS library, and he made this point about, he said it was like a knife dangling over his employees. He told me that the reason they were suing is for clarification about what the term harmful to children means. But I mean, in my private conversations with him, and I think based on reading the lawsuit, I think they're a lot harsher against the law. There's also just a lot of logistical issues with the law. For example, if a volunteer who's underage touches a book that touches All Boys Aren't Blue, and if a court's decided that's harmful, does a librarian have to go to prison? There's just a lot of logistical issues too. And I think one of the biggest problems in this conversation is that terms like harmful to children, it's just so subjective. I mean, Shakespeare and Moby Dick are filled with sexual references. And so then there's just kind of this question about where do you draw the line? And I think a lot of that made the judge kind of uncomfortable just based on what I read.
Thank you, Josie. And John DiPippa, again, the question, what is the status of the law passed earlier this year in the Arkansas legislature that opens up librarians to criminal penalties for providing harmful content to minors?
Well, Adam and Josie covered that pretty well. Let me just say a couple things about Judge Brooks's opinion. On the question of what's harmful to minors, the Arkansas Supreme Court officially says that any material that's harmful, that is, violates this Miller obscenity test, as to any minor, is harmful to every minor. And that really creates such a broad category of material that would be subject to a ban, so that a 17-year-old would be governed by the same legal standard as a 5-year-old. And Judge Brooks said that can't be so, because if you're going to restrict speech, it has to be narrowly focused on the harm you're trying to prevent. And you can't have a law that's narrowly focused when such a widely disparate group of people are being treated exactly the same. I mean, everybody knows, it's just common sense. A 6-year-old is different than a 17-year-old. And material for a 6-year-old is going to be way different from material for a 17-year-old. And that's the biggest problem this law has going forward, because the Arkansas Supreme Court officially interpreted it that way. And so that's the official way to read the law. And federal courts can't change that. They can't decide, well, we think that was wrong. They have to accept what a state Supreme Court says is the official construction of the law. And so a law that is that overbroad is always going to be unconstitutional. On the issue of appropriateness, which is the Section 5 challenge, that's open to anybody to challenge any book, even if it's not harmful to minors. Just what is appropriate? Well, there are no standards in the law that govern how that is ultimately going to be applied. And so in that sense, the law is vague, because a law has to tell people, especially in the area of First Amendment, exactly how they can behave and not violate the law. And it can't be so vague that it allows people to interpret it in a way that allows discrimination against different viewpoints. And so appropriateness is so vague in this context that that's going to be the ultimate problem for that section of the law going forward.
And if I can, I'll just mention this in what John was saying as well. Section 5 didn't talk about banning books completely, but it did talk about relocating them to an area of a library that is inaccessible to minors. And I don't know of a single library in Arkansas that has some sort of, seedy back room like you used to have in video stores. I know Josie's too young to probably know about most video stores by her own admission, but we don't have the beaded curtain section in the back of the library. And furthermore, from what cases have been decided, even in the state of Arkansas, saying that you have to, even in the Cedarville case, which Brian Meters was the attorney for, putting the Harry Potter books behind the desk and requiring a parental permission slip was an inexcusable violation of the First Amendment right of the students to be able to check out those books, because those books weren't illegal. They weren't unconstitutional speech. And so even putting a barrier up, like putting books behind a desk, was not, didn't pass legal muster. And what Act 372 required us to do was to place them in an area that is inaccessible to minors, which, as Josie pointed out, I've got a number of minors who work at my library and they shelve books. So what are they supposed to do when those books come across the front desk to be checked back in? Or if a patron wants to check them out, like, do they all of a sudden have to throw their hands up in the air and walk away? It just, a lot of the different what if scenarios that Act 372 created were just so obscene that, or obscene is not the right word, just absurd rather.
Yeah.
That it just made it impractical for us to be able to enforce.
And that also raises another point about the vagueness and the overbreadth, because on the criminal penalty part, the law says that the librarian can't make available or present material that's harmful to minors. Well, what does that exactly mean? And the librarian has to know the material is harmful to be liable. Does that mean that the librarian has to read every book in the library to make sure that there's no harmful content? Or, as the judge pointed out, what about the spine on the book? What about the title? What about the cover? Is that enough to tip off the librarian that it's harmful? And the law doesn't provide any guidance on that. And that's another issue, I think, that has trouble in the law.
All right. Well, thank you all very much for your insights on that question. If you all are just tuning in, you're watching Issues That Matter, Readers' Rights, a First Amendment discussion on book bans. This series is presented by the Central Arkansas Library System, the League of Women Voters of Pulaski County, and Little Rock Public Radio. This virtual forum is being recorded for broadcast and will air at a later date on KUAR 89.1. And we are nearing the end of our conversation this evening. As a reminder to all of our viewers, please put any questions you have for our panelists in the chat function here on Zoom, and we will have some time for those at the end of our program tonight. Well, moving on to our next question this evening, and we are going to go to you, Josie Lenora, first. Parents say they want to protect their children from seeing harmful content in libraries. What do you think is the best way of going about this?
Well, that's the thing, because Crawford County tried to relocate the books and now they're in the middle of a lawsuit. But what's interesting to me, too, is that there's so many libraries that are just tiny. I found one in North Arkansas that was one room. So it wouldn't really be realistic for them to create a restricted section just to contain this very specific list of books that are upsetting people. What's interesting to me is it seems like everyone can agree or says that they agree that libraries are good. Everyone disagrees with what a library should be. You have this one side that says a library should be open, a repository of different ideas, some of which are challenging and some of which you don't agree with. I mean, almost every library has Mein Kampf. But you have this other side that says libraries should be a reflection of the community they're in and only have books that the community's okay with. And then everyone seems to agree that parents should be allowed to choose what their kids read, but no one can seem to agree where we should put those parental controls or where we should put those managerial controls. I think that this debate, it feels like it's really less about like what kind of books we should read. It's really just a debate about what kind of community do we want to live in. And the books have become almost this like metaphor for that conversation.
Very interesting. Going next to you, John DiPippa.
I think Josie hit on it, that it really is about what sort of community people want to live in. And there may be a divide there that can't be bridged, because it seems to me that when you look at the topics people are objecting to, they're topics that are present in every community. I mean, there are LGBTQ people in every community, for example. And so if you want to make them invisible, if that's the sort of community you want, then you want to make them invisible in the library too. It seems to me that the other thing about these bills is that they're not really aiming for any practical outcome. Judge Brooks said he felt that perhaps the reason behind the bill, and Adam hinted at this, was essentially to terrorize librarians so that they would self-censor. And as long as there's potential for self-censorship, then a lot of these materials are going to be moved and librarians are going to err on the side of caution. And that may be the point, because it is almost no practical way to eliminate material that might be harmful for a young child, but is acceptable for an older minor. There's almost no way to do that and maintain a library in a way that is functional. I will say the one Supreme Court case that gives me pause on that is that filtering case. Because in the filtering case, the court said it's okay to block content through your internet connection in a library as long as an adult can unblock that content. And that they felt that it was a minor inconvenience to walk over to the desk and ask the librarian to unblock that material. And it seems to me that lawyers for the state might be arguing, well, it's a minor inconvenience for older minors and adults to go to a different section of the library. And so that may ultimately be the answer, to some different section.
Thank you very much. And going next to you, Adam Webb, again, the question, parents say they want to protect their children from seeing harmful content in libraries. How do you think is the best way of going about that?
Yeah, I would answer that question with a question and ask which parents. John pointed it out very succinctly that, if the people who live in Crawford County think that there aren't same-sex couples living there raising children, I've got news for them. And, parents are not monolithic. I've got same-sex parents who use my library religiously. And if all of a sudden, as their trusted library director, I said, you know what, I'm going to bow to political pressure here, and I'm going to put books about your family in some hidden area of the library because other people in our community find it uncomfortable. I mean, I can't do that. I'm not going to do that. And, to just say parents in general is this kind of catch-all term of saying like, well, what about parental rights? Being able to choose what is appropriate for your family is the ultimate parental right. And anyone who's listening to this, either live or later, who thinks that other parents should be telling you what is appropriate for you and your family, or the government should be making those decisions based on nebulous concepts like appropriateness, you should be outraged by this. And I know I am. I mean, it keeps me up at night thinking that I'm going to have to start making decisions in my library based on what one person thinks is appropriate over everyone else. I can't do that.
Well, thank you very much, Adam. Moving on to our last pre-written question for tonight. And again, we will have some time at the end for questions from our viewing audience. And we are going to start with you, John DiPippa. What do you expect will be the overall impacts of certain types of content being harder to access in libraries? Do you expect the book banning movement to continue or expand?
I think that I think the movement has legs, because it's part, as I said, of a long-standing and very sophisticated political movement that has only gained strength in the digital era. So I don't think book banning is going away. It seems to me that these first wave of statutes, like the one in Arkansas, are so clumsily written that they're, I hope, without a doubt, will be struck down. However, you can rewrite them in a way that works between the lines that the Supreme Court has opened up. As I said, there's still not a lot of definitive guidance from the United States Supreme Court. And so it might be possible to rewrite them, to be more specific about the content, to be more specific about what's appropriate, to have different guidelines for the procedure to use in all of these circumstances. That could possibly sort of, as I said, go between the lines. And if so, then I think a lot of the content that's already being objected to will be much harder to find, especially in smaller and rural libraries.
All right, thank you very much. Adam Webb, you are up next.
Yeah. I've been accused of being a delusional optimist by my colleagues. One called me the king of wishful thinking, which I love that song. But, there might be some legs to this. But the other side of this I mentioned earlier is this is driven in large part by meme culture. And if I've learned anything of being a digital native and growing up on the internet, it's that nothing lasts on the internet. People will move on to the next thing that they're upset about, or they'll find their next cause du jour to be annoyed by. And if ultimately a Supreme Court decision comes down in favor of libraries, which you would have to ignore a lot of precedent. I can't remember how many times the Supreme Court has used the if there's any fixed star in our constitutional constellation, it's that no official high or petty shall prescribe what is orthodox in matters of opinion. They've used that in a million cases, and they would have to ignore their entire history to say, well, we were wrong about that. Now, that's not to say that it's out of the realm of possibility, but I really expect that, I've been a fighter my whole life, and I can tell when somebody's getting punched out, and, people have swung and swung and swung, and they've won a few places. Patty Hector lost her job in Saline County. Deidre Guzmala left Crawford County, and then they had their social section. But by and large, one of my other jobs here is I'm the head of the Intellectual Freedom Committee for the Arkansas Library Association, and there are not a lot of book challenges that are being filed in the state of Arkansas.
Right.
I just don't think people, by and large, care enough. And when you look at polling in the Arkansas poll, where you have 80-something% of respondents saying that they really like what libraries are doing, they think libraries are doing a great job. It's hard to ignore that stuff as a librarian. It really kind of bolsters me to say, this is not going to be my reality for the rest of my career here. Because if I honestly thought the next 20 years of being a library director is going to be me fighting these battles, I might take Jason Rapert's advice and go jump in the Arkansas River right now and just be over with. But, otherwise, I think, I've got 60,000 registered users in Garland County. And by and large, they love the library and they love what we do. And that encourages me every day. It's what wakes me up in the morning and makes me go to work.
Adam, I just want to add, as a lawyer, I'm a professional pessimist. It's part of my job description.
All right. Well, thank you all so much for your input. Josie Lenora, you get the last word tonight. Again, the question, what do you expect will be the overall impacts of certain types of content being harder to access in libraries? And do you expect the book banning movement to continue or to expand?
It's hard to predict the future, but I know in Conway, there was a recent school board election where two more conservative people lost, and they had supported book banning. And that Conway's not a particularly conservative area. It was a close race, but they still lost. It is, Adam's right. Book banning and book relocations, they don't poll well. They're not particularly popular, but we do know that organizations and movements that kind of hide under this protect the children kind of a concept have been successful throughout time. There's a meme that I'm seeing on a lot of library book or book relocation Facebook pages, and it's a picture of a giant crowd of people. And then there's one person, and the one person has a thought bubble, and the thought bubble says, "You're all wrong." It's almost like this acknowledgement that they're in a minority. On top of that, though, Jason Rapert got appointed to the state library board, and him and Dan Sullivan have some kind of friendship. And Dan Sullivan has talked about how he thinks libraries are a bastion of liberalism and how he wants to defund them if they don't comply with these new rules. So, I don't know exactly what's going to happen in the future, but it does feel like, I don't know if the world is with the people who support book bannings and relocations, but I do think it could be that legislatively they're able to make some wins.
Yeah.
All right. Well, thank you all so much for your insights tonight. We have a question coming from Brent Carroll in the chat tonight. Brent says, have you found the best way to argue against book bans to the banners is to emphasize the work as a whole and its merit, or pointing out the need of the content in the community, or a combination of those two? And feel free, anyone who wants to tackle that, go right ahead.
Yeah, I'll take a swing at this one. Hello, Mr. Carroll. Glad to answer your question. You know, a lot of the folks who are participating in book bans right now, it reminds me of a quote from Barry Goldwater, who says that these folks think that they've been given marching orders by God and there's no reasoning with them. Now, that's not to say that there aren't reasonable people. We had some folks in Garland County who were ready to pick up the fight, and we were able to head it off, I thought, fairly successfully, just by hearing them out and, you know, maybe talking with them about, you know, well, these are the restrictions as a government entity of what we can do, but let's talk about some middle ground. And that's not to say that there aren't unreasonable people out there, but there are reasonable people as well who maybe have been brought into this discussion. And just those one-on-one kind of soft diplomacy kind of discussions, you kind of have to go into some really uncomfortable situations and talk to people who librarians typically don't want to talk to. But if you're willing to do that work and put in the miles, people will see you for who you are, which is, you know, you live in the community with them. You're their neighbor. I remember very early on when Act 372 was still SB 81, someone at the Capitol said these people are, you know, they've been brought into Arkansas from the West Coast and they're not your neighbors and things like that. I'm a 7th generation Arkansan. I've never lived anywhere else. My family toiled in the dirt down in Hempstead County for 200 years before we moved to Central Arkansas. So to say that we're not Arkansans and we're not your neighbors, you know, if you can peel enough layers of the onion away to show that, like, what you've been told is not true and these are the truths, most people can rectify that. Now, that's not to say that there aren't people who won't, or they just are so blinded by their own you know, guidance that they can't see it. But I think most people are reasonable in that manner.
I agree with Adam. Face to face conversations, that's the way.
I've found it's really hard for somebody to call you a pedophile to your face. And if you ask them just flat out, do you think I'm a pedophile? They'll say no. But you have to be willing to ask that question. You got to be willing to get in people's faces and be uncomfortable.
All right. Well, thank you all for your insights on that. Time for one last question from our viewers tonight. Thomas Bartol asks, what are your opinions on the Jason Rapert appointment and what can we do about that? And just for context, Jason Rapert, former state senator here in Arkansas, Republican, representing Conway and Bigelow, that area. Very conservative during his time in the legislature, and was recently appointed to the State Library Board by Governor Sarah Huckabee Sanders.
Well, Jason Rapert should not be on the State Library Board, period. He's got a worldview that is narrow and backward, and I think he is likely to cause a lot of mischief on that board from his point of view that would not be in the best interest of the state or its libraries. Now, what do people do? It's like any appointment. You try to let the people who approve the appointment, this would be the people in the state legislature, know your feelings on that. And that's really the only way.
Some members of the state legislature have said they're going to block his nomination. Right. I don't know how successful that's going to be. He is somebody who really does believe that conservative Christianity should impact every single state entity, like the library. So you do wonder, like, would he try to convert the library into something that it's not currently? I don't know, because he hasn't been officially appointed yet, but we'll have to see.
I would once again answer that question with another question, and this is more of an open-ended question to any state senator, which I know they have to approve his appointment. if you had someone who'd been appointed to, let's say, the Arkansas State Police Board or something like that, who said they think that police should be drowned in the Arkansas River. If you have any other board and you have an appointee come before them and say, I think those people should be killed, would you approve their appointment? I mean, it's absurd. And it's not even a matter of conservatism versus liberalism or whatever. I'm sure there are plenty of conservatives that you could put on the Arkansas State Library Board that don't think librarians should be drowned in the Arkansas River. I mean, if there was any question about whether this appointment was made punitively or as a way to scare librarians to get into order, I mean, I'd recommend you go and look at his record on what he said about libraries and his opinion of us as I don't even think he thinks of us as humans, but yeah, I also don't think he should be on the state library board.
Really quickly, someone in the chat asked who said that they were interested in blocking Jason Rapert, and I would say that Brian King, a state senator, said he was interested in blocking Jason Rapert. Just to answer that question.
Yes, I believe that was a week or two ago, maybe Senator King and Democratic Senator Greg Leding from Fayetteville also said they would block that. All right, well, thank you all very much for your insights tonight. This has been a very good discussion. That does conclude tonight's forum. I want to thank each of our participants for coming out tonight or staying in tonight and sharing their ideas. This has been the latest panel in our Issues That Matter series. Please share your comments on this forum and any ideas for future forums by emailing comments@littlerockpublicradio.org, or you can go through any of the social media accounts of the Central Arkansas Library System, the League of Women Voters of Pulaski County, and Little Rock Public Radio. Again, this panel discussion will air at a later date on the radio on KUIR FM 89.1. On behalf of the Central Arkansas Library System, League of Women Voters of Pulaski County, and Little Rock Public Radio, I want to thank you all so much for attending and have a great night.
Yep, thank you.